My name is Gonzalo Butori and I'm a Senior Associate in the Dispute Resolution team at DMH Stallard. When people think about legal disputes, they often picture long trials, stern judges and endless paperwork. But not all conflicts have to end up in court. An increasingly popular option is alternative dispute resolution, or ADR. ADR is an umbrella term that encompasses various non-contentious ways of settling legal disputes outside the traditional courtroom. The growing use of ADR reflects a shift in the legal culture towards efficiency, cost savings, and dispute resolution mechanisms that better meet the needs of the parties involved. At its core, ADR is about finding ways to resolve disputes that avoid the rigid structures, delays, and often high costs of litigation. Instead of having a judge impose a decision after a lengthy trial, ADR provides the parties with the opportunity to address the differences with the help of guidance of experts in their field. The focus is not just on resolving disputes more quickly, but encouraging solutions that can be more flexible and better tailored to the specific circumstances of the disagreement. As we said, ADR is an umbrella term that encompasses various non-contentious ways of settling a legal dispute, each with a different degree of formality and involvement. ADR is often explored before legal proceedings are issued, but it's not uncommon for the parties to consider ADR while the proceedings are ongoing. The main methods are mediation. A neutral mediator facilitates discussions and helps parties reach a voluntary agreement. Unlike a judge, the mediator does not impose a decision. Early neutral evaluation. A neutral evaluator will consider the case together with the parties' submissions and will evaluate the case as if the case was to proceed to court. The evaluator will then give an indication to the parties on the likely outcome of the dispute had the matter been referred to court. Again, the evaluator does not impose a decision. Arbitration. This is a more formal process where an arbitrator hears arguments, reviews evidence, and thus make a binding decision. It is often used in commercial disputes where enforceability is key, but it is more and more often used in other disputes. ADR has gained popularity worldwide because of its advantages. Among the most significant benefits are speed and cost savings. ADR processes are often far quicker and less expensive than lengthy court proceedings. The mediator, evaluator, or arbitrator's costs are usually shared among the parties. Flexibility and informality. ADR allows the parties for more creative and adaptable solutions that might not be available in a courtroom. Confidentiality. Unlike public court hearings, ADR proceedings are private, which makes them particularly attractive in sensitive commercial and family matters. Preservation of relationships. Because ADR is less adversarial, it can help preserve business partnerships, family ties, and other relationships that might otherwise be harmed by litigation. Control of the outcome. Finally, one of the most significant advantages is that the parties can control the outcome without there being a final, undesired, and imposed outcome. Nevertheless, ADR is not without hurdles. Particularly, mediation and early neutral evaluation rely on the voluntary agreement of the parties involved to participate in the process and does not produce a binding result unless the parties commit to one. This means that a dispute could remain unresolved if the parties are unwilling to participate or compromise. In many jurisdictions, including England and Wales, courts now actively encourage the use of ADR. Judges often recommend, and in some cases require, parties to attend ADR before a case can proceed to trial. Looking at the international perspective, ADR extends beyond national borders. In international commercial disputes, arbitration has become the preferred mechanism for resolving cross-border conflicts. This is largely because arbitration allows parties from different legal systems to agree on neutral forum, for which England and Wales remains one of the most popular for complex and high-value disputes. In conclusion, ADR is much more than just an alternative to litigation. It is now a central part of the modern dispute resolution landscape. By offering speed, efficiency, flexibility and confidentiality, ADR has proven itself to be a valuable tool in resolving disputes across a wide range of legal contexts.